Hello, this is revision tips for SIPS Level 5, Advanced Diploma in Procurement and Supply, and it's Module 3, Managing Contractual Risk. Learning Outcome 3, which is to understand and analyse the legal implications of contractual non-conformance in procurement and supply. So we're going to look at the remedies that are available for non-performance in contracts, the legal consequences of terminating a relationship, and look at the mechanism for dispute resolution in resolving conflicts. So terms and provisions can include in contracts to help ensure the smooth performance of a contract. That will include express terms, which are clearly specified and mentioned and agreed by both parties at the time the contract is made, either orally or in writing. And then implied terms, which can be judged to be present, but they don't necessarily need to be expressly included in the contract. There are things like the Sale of Goods Act and stuff like that are implied terms, any legislation. Change control covers areas like variations on prices, and that's often included in long-term contracts like construction or engineering. Benchmarking is used to check the market price of raw materials along other elements to ensure the supplier is meeting market expectations over the period of time. And you'd often see this included in long-term contracts like PFIs. Force majeure allows the parties to suspend or terminate the performance of their obligations if they're affected by the exceptional events outside of their control. Common examples will include acts of terrorism, war, fire, flood, industrial strikes, but the contract should also state which actions can be taken as a result. And the limitation of liability is a provision that limits the financial exposure of one party. A cap is agreed to limit the party's exposure in the event of a claim for damages. And alternative dispute resolution clauses describe which methods of resolutions are available if conflict does arise. Now, many contracts require a default notice period before a termination process is issued. A default notice alerts a party to the reasons why the other party believes the party is in breach of contract. This requires the party receiving it within the stated amount of time to take steps to remedy the identified cause or issue and explain why the party is not or no longer in breach of contract. The primary aim of a contractual notice regime is to provide a party in breach the opportunity to remedy the notified breach and to avoid termination. If the issues persist, then default notices become part of the necessary contractual requirements for valid termination. But other default clauses will include things like force majeure, where neither party can be considered to be in default because its obligations under the contract, to the extent, can establish that the performance of such an obligation is prevented by a circumstance of force majeure. And that arises after the date of the contract, which was unforeseeable at the date the contract was signed. Liquidated damages, penalties, and unliquidated damages are clauses in the contract that help to provide some financial remedy to the injured party. Liquidated damages is an estimate agreed prior to signing the contract of any damage that may incur as a result of breach. The value of the estimate can be identified as a fixed sum or a percentage of a specific milestone, like 1% of the invoice amount for every week a delivery is late. Penalties is a financial sum which is agreed before a breach occurs and typically before the contract is signed. This is not a genuine estimate of the cost of the impact of any breach. It's used to punish rather than deter a breach, and most commonly it isn't enforceable. And then unliquidated damage is another method that allows one party to claim damages from another in the event of a breach, but it doesn't specify the amount that can be claimed because it's not possible to calculate that in advance. Consequential loss or damage, sometimes referred to as special damages, is losses that can be linked to a failure of a party to meet their contractual obligations. So, for example, the loss in value of a product due to changes in the market or loss of profit or damage to reputation, depreciation, a rise in material costs, interest and finance charges. They can generally be claimed by a party if They were reasonably predicted or expected at the time the contract was formed. More proof is needed in order to claim for a consequential loss in comparison to what's needed to claim direct losses, like repairs and replacements. Service levels are used to indicate the level of performance and delivery expectation during the term of the contract, like a cleaning or an ICT support contract. The service levels should be SMART to avoid ambiguity, so that's specific, measurable, achievable, relevant, and time-bound. And the supplier's actual performance or delivery of the service is compared against whether that was contracted or not. And if the performance fails to deliver the agreed level, service levels are used to ensure that suppliers fix any causes of the reduced performance. And service credits will be issued. The deduction of the amount from the service based on the extent to which performance failed to meet the levels set. So let's say you had an internet provider who guarantees to provide you with internet connection 365 days of the year at a certain price, but for whatever reason, no fault of your own, the service is unavailable for 2 weeks from that 365 days, you would be entitled to a reduction in the cost for the time you couldn't use the service, and that is a service credit. And then you've got key performance indicators. They're commonly used in service contracts, but they're not the same as service levels. There is no associated mechanism for service credits to be awarded in the event that performance falls below the expected KPIs. Service levels are not replacements for KPIs, but KPIs should be included as they can indicate bigger problems. So service levels versus KPIs, what they are is quantifiable measures that are actionable, a way to measure factors that are critical to the success of the organisation, tied to goals and targets, limited to maybe 5 to 8 metrics and applied consistently throughout the contract. But what they are not are metrics that are vague or unclear, nice to knows that require no action, reports, an exhaustive set or refundable in any way. So those service credits I mentioned earlier, normally breaches are discussed in terms of payment or court cases, but some contracts for services, cleaning, security, internet providers, the most effective remedy can involve more work. So the supplier may provide some service for free for a period rather than there being a cash payment. This would work whether both parties are still comfortable working together. But more serious breaches or where one party wanted out of the contract, it wouldn't work, as the willingness to perform the work and the relationship required won't be there. So service credits can be used when there's a service level agreement or some means of calculation. Service credits are a mechanism by which amounts are deducted from the amounts to be paid under the contract of the supplier. If the actual supplier performs below the standard, the contract may include various mechanisms to rectify that poor service, such as service credits. This would be viewed from a form of liquidated damage as they replace the amount deemed to have lost as a result of the breach, but they're more likely to be used in the event of a warranty term being breached or where an injured party affirms the contract, i.e. they want or need to continue. It has the assumption that both parties are comfortable with continuing to work together. But let's assume you're not continuing to work together. You might want to serve notice. Notice clauses designate methods to bring notice issued under a contract to the attention of the other parties. They fix a method and means for delivering documents required to be formally served in compliance with the terms of the contract. In other words, where a contract requires a recipient to be made aware of the facts and matters in question, a notice clause defines the way it may be brought to their attention. Just because a contracting party knows about the notice, it doesn't mean they have been properly served under the contract. The difference between the two can make all the difference. So the purpose of the notice clauses is in many situations, a business contract requires that the other party be notified of the existence of legal rights under the contract. And that is to give fair warning in advance. Contract notice provisions set out the means by which the other party can bring the attention to the other party. So examples in exercising the right to terminate would be the right to terminate a construction contract for reasons such as poor performance. And that's a crucial consideration and contractual right. But if exercising the right to terminate is not carried out in accordance with contractual notice requirements, then a party risks invalidating terminating the contract and exposing itself to wrongful termination action. Recent case law in the UK and Australia served in a timely notice that a valid or invalid termination can start with the contractual default notice. So it may require a default notice before the termination notice is issued, and the default notice alerts the party to the reasons why the other party believes the party is in breach of contract. It requires the party receiving it within the stated amount of time to take steps to remedy the identified issues of a project or explain the reasons why it's not or no longer in breach of contract. The primary aim of the contractual notice regime is to provide a party in breach the opportunity to remedy the notified breach and the associated costs. And ultimately, it's about avoiding termination. If the issues persist, then the default notice becomes part of the necessary contractual documents for valid termination. And then we've got the assessment of damages. Assessment of damages, there are three measures of damage. You've got expectation measures, reliance measures, and restitutional measures. Expectation measures attempt to position the innocent party in the situation they would have been in if the contract had performed as expected. The claimant is also likely to be able to recover any consequential losses, which may have been suffered as a result of the breach, such as loss of future business. Damages are calculated by looking at where the innocent party would have been had the contract been performed. Reliance measures is to take a backward-looking approach to the calculation of damages, and that's to return the innocent party to a position where they were prior to the contract being agreed. These measures are used when it's challenging for an innocent party to calculate the profit or benefit they would have realised had the contract been performed. Instead, the innocent party may claim to be reimbursed for any expenses that they incurred in anticipation of the contract being performed. Expectation damages and reliance damages are alternative measures. They cannot both be awarded. And restitutional measures typically award when one party has provided a benefit or performed a part of their obligations under the contract and the contract becomes unenforceable. In such instances, these restitutional measures look to award the party that's performed part of their obligations with a proportionate value of payment. For example, a painter contracted to paint a house, but the house burnt down when he's halfway through. The painter will be paid for the work that was done so far. I'd also suggest you look up quantum meruit, which is a Latin term that explains a very similar situation. Then we're going to look at contractual warranties and conditions, and the difference between contractual conditions and warranties matter because the scale of the impact of the breach. Each term within a contract, whether expressed or implied, can be classified as either a condition or a warranty. A condition is a vital term which, if breached, may be treated as a failure to perform a basic part of the contract. You have an option to terminate and claim damages. A warranty is a non-vital term, which is an incident to the purpose of the contract, and it's incidental. So an example, if you buy a new house, it could be a condition that it was habitable and meet the housing regulations, but you might have asked for the hot and cold taps to be a certain way round. This would be a warranty. It wouldn't allow you to render the house inhabitable or breach of legislation. So a warranty would only allow you to claim damages. Specific performance is similar to the remedy of injunctions which are available in common law, but what the requirements are for specific performance to be awarded. Firstly, the lack of availability of adequate remedies. So, in the event of any breach, the first remedy that could be considered is financial damages, but in some instances, damages cannot compensate for the consequential losses which have resulted as a breach of contract. The second is the contract needs to be valid and enforceable. So, adequate considerations need to be given to the contract so that the exchange of goods and services for financial reward is fair. In addition, there also needs to be a degree of certainty as to what the terms of the contracts are trying to accomplish. Has the innocent party performed its obligations under the contract? The courts will consider to what extent the innocent party has performed or is willing to, or able to perform its obligations under the contract. And the balance of interest and hardship. As specific performance is seen to be an equitable form of remedy, the aim would be to return the parties to a position where they would have been had the contract been performed as intended. But the reasons for terminating a contract would be if there is unsatisfactory performance, if one party refuses to perform their obligations, if there is a breach of terms like confidentiality, if one of the parties goes bankrupt, if there's a change of ownership in one of the parties that may result in a conflict of interest, if a party may no longer be able to fulfill its contract due to the availability of resources or cash flow, and if there's a major or fundamental breach. Termination clauses may expand or limit the right to terminate a contract, which would normally be given under common law. Needs to be mutually agreed by the parties in advance. This is likely to involve discussions at the negotiation phase that can allow the parties to terminate a contract by mutual consent and mutually agreed actions before the performance of a contract. It may include a fee or may identify specific actions which a party may not do, such as sharing details of costing with a third party. And it's usually included in a term that's reasonable when notice is given. And to recap on some of those mechanisms for dispute resolution we looked at in Chapter 2, these are methods of resolution that range from informal on the left-hand side to more formal on the right-hand side. So the level of formality and collaboration involved in each increases when you move from left to right. So negotiation outcome is decided by the parties, whereas litigation, somebody else decides the outcome for you. Consensual methods, a third party is introduced to facilitate the process of reaching an agreement. And adjudication methods is where the third party acts as judge or sole decision maker in relation to the outcome of a dispute and how it's resolved. The guidelines for dispute mechanisms state that they should be legitimate, adequate, and equitable, with rights comparable so that it's not prioritising one over the other. The aim is generally to resolve the matter as quickly as possible so the performance and obligations under the contract can resume. And that's the end of Learning Outcome 3. Thank you for watching.